consequences. So you see, when there is a, storage of some chemical, and you have taken the reasonable care for that, then you are not responsible as there is the application of the negligence theory. So that's why you can prove, when you say that the occupier or the industry is negligent, then you have to prove it. Then the attack, whether he has taken the reasonable care or not. If he has taken the reasonable care, he is not responsible for the consequences. He is not responsible for the loss. Can be a relevant theory to fix the liability in the industrial catastrophe, industrial accidents, or these gas leakages, etc. What is the base of liability? So when totally you rely on the theory of negligence, highly difficult to prove the reasonable care, whether it has taken or not, even if it is proved whether it is reasonable care or not, then you have to think about the damages, etc. So all this must be proved. And so to avoid all these things, to avoid the problems while application of the negligence theory in some cases, especially with reference to these serious issues like the industrial disasters, and the courts are not silent. Courts have also at every point of time tried to innovate new theories to fix the liabilities. But of course, it considered to be very new. I'm referring to a theory that has been developed in 1868 in England by the House of Lords. This is a very famous case. The case is known as Rylands vs. Fletcher. Very, very important case. So there, the House of Lords clearly laid down by saying that if anything has been keeps in the presence of somebody else and it escapes from his custody irrespective of the reasonable care, then he will be responsible for the consequences. That means if you keep anything on your land and it escapes from your possession, from your custody, whether it is a willful act or negligent act, that is irrelevant, and you will be reasonable, you are responsible for the consequences. The consequences is the loss that has been caused to other party. So that's why, basing on the theory, then in the industrial accidents, they will try to, impose the liability. Another theory that has been applied and generally we know is res ipsa loquitur. Res ipsa loquitur. That means it is a Latin term. It says that the thing speaks for itself. The thing speaks for itself, because when you keep the hazardous substances on your land, generally you will be responsible for the consequences. So knowingly that you keep the hazardous substances or the things inherently dangerous for that industrial activity, then you will be responsible for the consequences. So that's why here the two important things under the law of torts which provide the civil remedies to compensate the victim, offers a very effective protection. So the number one is laid down in the Rylands vs. Fletcher by the House of Lords, the rule that is popularly known strict tort liability, strict liability. So basing on the strict liability, you are responsible for the consequences, even though you have taken the reasonable care. The second one is res ipsa loquitur, which allows the victim to get some compensation from the wrong of others. But when I also refer to how these rules are applied to the Indian context, that's very important. Because the apex court, the Supreme Court has, just applied these, rules of liability to different cases, in different cases. But when go back and talk about the Bhopal gas leak tragedy, or you can say Bhopal gas leak disaster, and what happened in the case is, and as I told you, more than 3,000 people died and 500,000 people affected with the gas leakage. Then I said the justice must be done to them. What the justice? Because you must see the safety and the health of the people even after the disaster. Then they should get, when there is a loss to the property or to the human loss, it should be compensated. And all these people filed the cases in different courts. At that point of time, what the government of India has done it. The central government, you can say, and they passed some sort of legislation stating that go and pass the legislation, and the government wants to proceed against the wrongdoer, that is the multinational company. Here you see, Iran Carbide in the Bhopal gas leakage, Union Carbide, the parent company incorporated in US has been involved because here we have the Union Carbide Corporation Limited in India. So that's why we have to proceed against the parent company, but the parent company is in the US, and the victims are in the affected parties in India. So the Indians can imagine the Indians can file the case in the US for get more compensation. Why
Okay.
you want to proceed to US? You want to get some more
Okay, I got
compensation.
it.
So that's why
Okay.
instead of
Uh,
filing the cases
I
in the
got
local
you.
courts,
Thanks a lot. Thanks.
and this the government of India passed a legislation that is the Bhopal Gas Leak Disaster Act 1985, and preferred to file the case in the US on behalf of all the people, all these affected people. But they also apply the doctrine of parents patria, because this principle has been developed in England, saying that the king is responsible for the interest of all the people. Basing on this doctrine, this Indian government preferred to file the cases in the US. But what happened in the US? Lord Keenan in 1986 directed and sent back all these, these petitions and also these complaints or these claims to India, stating that Indian courts are competent to try the cases. So that's why, and all these claims have been returned, and they were returned, and again the government of India finally, filed cases in the Indian courts to get the compensation. Whatever it may be here, this was also questioned by some of the people in the General Law versus Union of India in 1989, stating that because of the constitutional validity of these legislation, that is the Bhopal gas leak disaster, how the government is competent to file the case on behalf of all the people. But the court has said, the Supreme Court has said, no, the government is constitutionally valid. The government has every right to protect the interest of all the people, its citizens, and given the permission to proceed further. But here I wanted to mention another case, that is, uh, this is the leakage of oleum gas in the Serum fertilizer plant in Delhi. So 1 decade later, this happened. So in MC Mehta, he is the activist, and filed many cases against the
You know, but the first 2 3 days, I was getting any problem, but yesterday,
Any problem?
but it will take too much time because few students were there, so
Okay.
No, sir, we can carry on.
Okay, so another case filed in the court by MC Mehta. So questioning the liability of the Sriram fertilizer plant in Delhi regarding the leakage of oleum gas. So the court, applied, the refined theory of strict law. I referred to strict tort liability with reference to Reliance facility earlier. So I said the House of Lords, innovated and also introduced the strict tort liability, in Reliance versus Fletcher. But here, the Indian court has gone further to refine the rule of strict liability and said, because strict tort liability is exceptions, they have given it. So that's why, to avoid all these exceptions, because whenever there's an exception, the industrial concern will try to escape by showing the legal, and get some sort of the, advantage. So to avoid that, the Supreme Court of India in MC Mehta versus Union of India, and applied the rule of absolute liability. So that's why here we have the strict tort liability applied in this Reliance versus Fletcher, and this absolute liability theory applied in this MC Mehta versus Union of India. So that's why they said this industrial concern, the corporation is corporate entity or the body is liable for the consequences that have taken place because either the willful act or the negligent act. So that's why this is a very important rule, that is the rule of absolute liability, a defined law or the exception of the principle of strict liability that has been applied by the Indian courts in MC Mehta versus Union of India. This is, about the civil remedies under the civil law to make the industrial, entity liable for its negligence, especially in the case of industrial disasters. But another thing is, what about the corporate criminal liability? This is also very important. When you talk about, do you mean that if something happened, some industrial accident happened, some compensation that has been paid to these victims and of the affected people? But the issue is, can you make this industrial, the corporate body responsible for its liability? Suppose when you talk about industrial disasters or accidents, generally the corporate bodies, just all these things happen within the premise of the corporate bodies or the factories. The issue is, can you make liable the corporate body? Corporate body means it is a legal person. It is totally different from us, from this natural person. You are the natural person, but the corporate body is a legal person. So that's why it is a person, of course, under section 711 of the IPC. But the issue is, can you make them liable? Suppose in the case of civil liability, pay the compensation. In the case of criminal liability, you have to punish the wrongdoer. You have to put them behind the bars. How to, put the corporate body, a corporation entity behind the bars? Because it is only legal person, it is only on paper, it is only in the books. Because of the incorporation and the Companies Act, and it gets some sort of a legal personality. So how can you make the corporate body? Can you put the industry, the fiscal content of it behind